Article 207 of the Indian Constitution lays down special provisions regarding financial bills. Here's an explanation of its key points. 1. Introduction or movement of bills. A bill or an amendment concerning certain specified matters listed in subclauses A, 2, F of Clause 1 of Article 199 cannot be introduced or moved in a state legislative assembly without the recommendation of the governor. Additionally, such bills cannot be introduced in a legislative council. However, it's important to note that no recommendation from the governor is required for moving an amendment that proposes the reduction or abolition of any tax. 2. Scope of matters covered. The provision clarifies that a bill or amendment won't be considered as making provision for the specified matters solely because it includes the imposition of fines, pecuniary penalties, fees for licenses, fees for services rendered, or the imposition, abolition, remission, alteration, or regulation of any tax by a local authority or body for local purposes. 3. Expenditure from the Consolidated Fund. A bill that, if enacted, would lead to expenditure from the Consolidated Fund of a state cannot be passed by a house of the state legislature unless the governor has recommended its consideration to that house. These provisions ensure that the process of introducing, amending, and passing financial bills is guided by certain rules to maintain fiscal discipline and ensure proper governance. The role of the governor is significant in these matters, particularly in safeguarding the state's financial interests and ensuring that any expenditure from the Consolidated Fund is done with proper authorization.
The Constitution of India. Part 6. The States. Chapter 3. The State Legislature. Procedure in Financial Matters. Article 207. Special provisions as to financial bills. 1. A bill or amendment making provision for any of the matters specified in subclauses A, 2, F of Clause 1 of Article 199 shall not be introduced or moved except on the recommendation of the governor, and a bill making such provision shall not be introduced in a legislative council. Provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. 2. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of a state shall not be passed by a house of the legislature of the state unless the governor has recommended to that house the consideration of the bill.